Good afternoon, everyone. Thank you for joining us this afternoon. I am Attorney Wilda Pomales. I am the family law attorney here at the Legacy Legal Team. Today, we will be discussing equitable distribution while going through a divorce. And what is equitable distribution? And that is the legal avenue that the court uses to divide the assets and the liabilities within a marriage. And sometimes the question, I guess, mostly asked during the divorce is if the property or the bank account is under my name, does it need to be divided? And according to the statute, pursuant to the statute, the Florida statute, the court starts off with everything being 50-50, 50-50, unless the court can justify an unequal distribution. And so there are steps that the court takes to determine how are we going to split these assets and these liabilities? How are we going to divide? Which party is going to be responsible for taking on that debt or taking a portion of that debt? What's that portion going to be, right? And so the court must first look at what is a marital asset or liability and what is a non-marital asset or liability. And so there are a couple of factors that the court needs to look at to determine what category each asset or liability will fall under. And just because, let's say you purchase a house before you get married, and then you get married, and then a divorce starts, the property does not automatically stay as a non-marital property for either party, right? And so there are certain factors that need to be determined there. For instance, did the mortgage, if there is a mortgage, did the mortgage get paid with funds that belong to the marriage, funds that were earned during the marriage for either party? Were there repairs that were made during the marriage with marital funds? And so while the entire property or the entire value of something may not be all marital, but there may be a portion or a component of it that may be a marital portion. And so the court will have to determine at that point, what is that marital portion and how will it get divided? And so when we're looking at this, it takes a little bit more than just looking what that bank account is or what that credit card account is and determining, okay, we a lot of times get asked if I've always kept my bank accounts and both of us kept our bank accounts and our credit cards separate and we never jointly owned anything and we spend our own payroll for our own expenses and divided the utilities and the mortgages in half and paid out of our own accounts, does that make that divorce easier? And as mentioned, just because it's titled under your name or owned individually does not make it a non-marital asset. And so typically, if you don't have a prenuptial agreement and you've been married, we have divorces that the parties have been married for 50 years. Typically, everything will be a marital asset because you've built everything together. And so with the efforts and the funds earned, income earned during the marriage, you both have certain assets that you have acquired or liabilities that you have incurred during the marriage. And so most likely it will be a marital distribution or marital equitable distribution that needs to happen. And so for that, we always advise that you seek legal counsel and we can schedule a consultation. We can go over what the case is in your dissolution, and if not two cases are ever alike. And so we need to determine what may be marital, what may be non-marital. And so this week we'll do part 1 of equitable distribution. And next month we will do part 2, because as of July 1st, there will be changes in the equitable distribution statute here in Florida. And so there may be additions that may change things. And so we can discuss what those changes will be. As of now, as I said, there are factors that the court needs to look at and factors that may determine whether one party is awarded a little bit more than the other party. Those factors can be the length of the marriage, the contribution that each party gave towards the marriage, such as one person worked the entire time and the other party stayed home with the kids, raising the kids. And so the education level of one party that stayed home may not be equivalent to the other party. And so there may be some equitable distribution that may go to the party that has not had this career, so that way they can get back on their feet and or be able to continue raising the kids, whatever that case may be. The main thing sometimes is the home, the marital residence. One party may want to stay there, continue to raise the kids, continue to keep them in that same school district. They may not be able to buy out the other party from their marital share of that equity. And so the court may determine that for the time being, one party will have exclusive use of that property while the kids are still in school, underage. And so at the time that they age out, then maybe the parties can sell the property and then at that time divide the net proceeds. And so that all has to be looked at when determining how are we going to be splitting the assets and the liabilities. The other question that we get asked a lot is, I did not know that my spouse was incurring this debt, and so am I still going to be responsible? And again, every case is different, and so the court will look at if one party dissipated funds, marital funds, and so were they were they using the credit cards on an extramarital affair, things like that. And so is that something that we can prove with the courts? And so it'll take that non-spending party, let's call them that. It'll take them proving whether that other party dissipated those funds, and will the court award the other party that entire debt, make them responsible for that entire debt. So the simple fact that you did not know about the debt, unfortunately, does not clear you from being responsible for that. And so we have cases in which a party we've had them 70,000 into debt, and one of the other spouse did not know that those debts were being incurred. And unfortunately, they were all spent going on vacation, paying bills within the household. And so that was all determined that it was marital debt that was incurred, and both parties were equally responsible for it. And so the situations vary from case to case, but that's why you would need to schedule a consultation for us to determine what that strategy will be to be able to distribute the equitable distribution as for the assets as well as the debts that have been incurred. And so currently, let's see the factors, again, going back to what influences the equitable distribution. So you have the contribution to the marriage, as I stated, which again includes both financial and contributions made as a homemaker, economic circumstances, and that's of each spouse during the divorce at the time that the divorce is filed. You have the duration of the marriage. And as of last year, the short-term marriage, moderate marriage, and long-term marriage, a number of years were changed. And so for a short-term marriage right now, it's from the start of the marriage until year 10. And then moderate length marriage is from year 10 to year 20. And all other marriages above 20 years, that's going to be a long-term marriage. And so the duration of the marriage will also determine what that distribution will be. Just to give you a quick example, and again, all cases are different, but we've had divorces that have happened after a year of marriage where one party owned a property, owned all the assets, never included the spouse on the deed or the mortgage or anything like that. And so at the time of the divorce, the court awarded the spouse that had this premarital property, awarded them the property. And so that was not determined that it was an equitable distribution needed there. And so again, it will vary because depending on where the funds came, of how that mortgage got paid, who put those funds and how were they obtained, that all makes a difference. But those are just certain scenarios of what could happen. So just because you marry someone, do they get 100% of the distribution of what you had prior to marriage? No. But we would still need to run the numbers and determine, according to that formula, and what is that appreciation, right? Whether it be a passive, active appreciation within these properties, what does that look like? What is that percentage? And that all is statute based. And so that is something that we need to run and calculate. And so it's not as easy as determining, okay, one person will get 50,000, the other person will get 70,000 off of the value of the home. It's more of trying to find out how that math plays out. Another factor is the interruption of careers or education. As I stated, maybe one party stayed home the 20 years of the length of the marriage, raising the children, while the other party was out excelling in their career and advancing and obtaining further education to further their family's being. And so that also will determine of that, what that distribution will be. Desirability of retaining the assets. Again, if one party is wanting to stay in the home versus moving or selling the property, and what does that look like? Just because you do not agree on whether one keeps it or sells it does not mean that it has to be sold, right? And split right away. The court can determine based on the children involved and the best interest for the children what that distribution will look like. Another one is intentional waste or dissipation. And again, that is if one party was just splurging on extramarital affairs, and the court can determine that income incurred or marital funds that were depleted come back through a different asset. And so if we find and we are able to prove to the court and show them with bank statements that $30,000 in savings was used up for extramarital affairs, then when you're splitting the net proceeds of the property of the house that is getting sold, maybe you get that party that was the non-breaching party can get an additional 30,000 from, or whatever that amount is, additional 15,000 from that sale of that home versus the other party. And so there are other factors that may come into that, but those are just some of the factors that the court has to use to determine. And it gets a lot of times people just want to know that number, right? Before they even start the divorce, they want to let you know, I have this much, X amount in assets, my house is worth this much, how much am I going to be receiving? And unfortunately, during a consultation, that is not possible to determine. The analysis of the financial documents for both sides will have to be completed before we can give rough estimate or a determination or advice, some legal advice as to what may be the split or a reasonable split of equitable distribution. And so it takes a little bit more than just a consultation to determine that, but we will be able to guide you as to letting you know what the statute currently states. And again, as I mentioned, July 1st, we will be having changes in the statute. And so we will determine, okay, what is it, how is it going to change, and how does it affect what currently stands at this time? And of course, this is absent an agreement, right? If you and your spouse reach an agreement as to what that split will be, you are more than, actually it's encouraged, right, that you reach an agreement versus the court determining how the assets and liabilities will be split. And so absent an agreement, we have to defer to the statute. And so there may be a prenuptial agreement as well. And so all that comes into, but if there is none of that, then we need to determine based off of the statute. And so we'll be able to assist and guide you in determining how that can happen. But again, it would have to be after the consultation and maybe more so during the representation to determine what that split. Let's see here. We have a question. The question is, if I am a stay-at-home mom, is there an exact percentage that can be attributed to calculate my distribution? And so the first part of that question, there is no exact calculation. And so the court has to look at the totality of the assets and liabilities within that marriage. And so we need to determine, because again, if the household is the biggest ticket item and that marital home is the biggest item, but then the marital debt is super high. Maybe neither of the parties are able to afford the property. And so we're going to need to determine that whether the affordability, will that person qualify to be able to stay in that property by themselves, be able to afford the expenses. And so that all needs to be determined. And so then the second part is, will the July 1st statute have any information about that? As far as we know, July 1st, and again, we'll get into the July 1st changes next month, but once they're actually finalized and they come out. But from what we know right now, it is more to enhance the statute and be more clear as to the definitions. What is an asset? What is a non-marital asset? What is a marital asset? And further guidance for the courts to be more specific. And so it may be to add more to what already exists. But from what currently exists, there is no clear percentage that we are able to say you will for sure receive 30% more or less than what the statute presumes it at 50-50 split from it. And then, will the distribution be calculated based on the current financials, or is past information also taken into account? And so that is a very good question, because sometimes people start planning for a divorce, meaning they start losing their jobs or quitting or taking a less paying position, because they know they may be fighting for a divorce and they don't want to be responsible for any potential alimony expense, or for the same reasons they don't want that unequal distribution more going towards the other party. And so the court will determine whether the past will be needed. And so the court can impute previous earnings for either party. And so if somebody does try to deceive and try to voluntarily become underemployed or unemployed, then the court can look at what the past earnings of either party has and what that change looks like. And so they can determine that the distribution is based off of past wages being earned, or whatever the case is in that matter. Or if the spending, if right before you start filing for a divorce, you start incurring a lot of debt, the debt may be determined that it is only the responsibility of that person, of that spouse, that incurred that debt. For those reasons, because sometimes, unfortunately, people start planning their divorce and start making certain transfers, certain purchases, depleting the funds in hopes that the court will not award them any less than the other person, or may not award the other person as much. And so that is also a concern, mostly when there are long-term marriages or a party has been a stay-at-home parent. And so they are now scared as to what will happen. Will they be able to afford their the same standard of living going forward? And so that's what the court needs to look at when determining that equitable distribution. What was that standard of living? And so if we will award, let's say if the court will award the marital residence to one of the parties, will that party be able to afford that? Because last thing we need is foreclosure to be in the near future and the family is out of the opportunity of being able to make a sale or a profitable sale for either party. And so the court will always look at that and determine what is best. And so, again, when we're looking at what that distribution is, we're looking at what exists, the totality of the marital assets and liabilities that have been incurred. And so at our office, you will be given that Excel spreadsheet, what we're looking at, the finances that we're looking at, the analysis. And so we will review it with the party, our client at that time, so that we're able to make that decision, or that the client is able to make the decision as to how they would like to settle the case. Because again, it's better to get into an agreement versus letting the judge decide how these splits will happen. Another question is, can both my spouse come to an amicable agreement, or is it best to go alone? And I know we've had other videos that state the difference between going self-represented, pro se litigant, versus being represented by an attorney. And so we always recommend that at minimum you have an attorney review these agreements, right? And yes, you and your spouse can come into an agreement, draft the documents together, and sign them, execute them. But before you submit them to the court, we always advise that you at least have a consultation with us so that we can review these documents. Because what happens is that you may leave certain information out, and when the court submits that, later on you try to enforce something because one of the parties is not complying with what the agreement states, and so you will have a hard time enforcing that for the courts to enforce it. An agreement is very vague or it does not include the information that the court needs to be able to enforce that agreement, and so you're stuck with having to modify something, and it may cost you a lot more in the long run. So if you have an agreement, definitely it's encouraged for you and your spouse to discuss these issues, but before you submit anything to the court, have a consultation with us. We are able to, as we've stated before, provide unbundled services where we don't need to represent you from beginning to end, but we can review your agreements. And so we'll make sure that the agreements state the language that it needs to state, that it's properly drafted. We can also assist you with drafting the agreements, and you can then go ahead and submit that to the court. So that way, in the long run, you are not paying more or your family is not affected, right? Sometimes it's inadvertently done where you leave something out and then you may try to go have the mortgage changed over or the deed redone, and then you can't because the document really is not giving you that authority, or the lender does not think that the document was drafted properly, so you cannot switch the mortgage from one party to the next to the other party, and so you essentially cannot do what you intended to do, and so you'll have to come back to the court system. And so before you get those agreements done, please have a consultation with us, give us a call, and we'd be more than glad to review anything that you have before submitting to the court. So yes, it's possible that you represent yourself, but at minimum have us review those documents for you. Let me see the statute here. Another thing is the court determines that there is that the property, the asset, whatever it may be, is non-marital, then it stays out of the equation. It is no longer part of the distribution, and it's as if it didn't exist. And so the party that it belongs to, that the court determines is the rightful owner of it, or the individual owner, will get that granted. And so another thing that the court needs to look at is that cutoff date, right? When are we going to give that asset or that liability that cutoff date of when we stop incurring any more expenses, or the value that we will give the home? As of what date are we looking to divide that property? And so unless there's an agreement, if there is a written agreement between the parties that clearly states the date that you want to use, the court typically uses the date of filing. And so if you file today, the liability that is incurred tomorrow, if somebody goes and splurges and buys a new car, the court can determine, no, today was the date of filing, tomorrow's expense belongs to the person that incurred that expense. And so there's that valuation date of when we shall determine, when we can determine what that value is. It gets a little tricky with investment accounts because the investment accounts fluctuate, right? You have a certain number of stocks per se, and that value can go up and down. And so it is harder to state as of today's date, January 27, 2024, each party is entitled to $10,000 of this $20,000 retirement account. By the time the final judgment comes in, other documents are needed, maybe a quadra is needed to split that account, there might be less in the account. And so For certain accounts like that, the court will determine that the benefits of that account as of the date of filing, which if we're using today's date, the benefits to a retirement account that exists as of June 27, 2024 will be equally divided. And instead of putting an amount, they're putting the benefits. And so it'll be up to the provider to determine, okay, if there were 10 stocks, each party gets 5 stocks, and whatever that value is what they will be transferred into their separate accounts. And so that is all that will have to be determined if the court needs to make that decision. Again, if you guys are getting into an agreement, the parties can agree to anything, a flat fee, a percentage, whatever it may be. But if the court is determining that, then that is something that the court needs to look at. What type of account is it? A retirement account? Is it a property? Are we doing appraisals? What appraisal are we using? And so that way, if accounts go up and down, we already know what will occur after final judgment is entered. Let's see, anything else? Alimony also ties into the distribution because a lot of times a spouse is seeking alimony, there may be an initial need, but depending on what exists within the, again, marital assets and liabilities, that may be accounted for. So the court will determine that split and then determine that alimony allocation as well. And so the alimony is a separate statute, but we will see if there are any further changes after the July 1st change. I think that will be it as far as the equitable distribution goes. Let me see if we have any further questions. Again, if you have any other questions pertaining to this topic, feel free give us a call at the office. You can also look at our online resources to be able to see your answers, your questions can be answered there. Otherwise, feel free to give us a call, set up a consultation. We'd be more than glad to assist with any questions that arise and be able to guide you as far as what the statute says at that time, how it pertains to your situation, and what further steps you can take to make that decision on whether a divorce is the only route or how we can do it. Again, we can do it the amicable way, the collaborative way, which is always what we recommend here for the best interest of the family. So if there are no further questions, I appreciate you all taking the time out of your day to sit here and listen. If we can be of any assistance, feel free to give us a call.